and take item number 5, correction of vote and proceedings and official reports, starting with the vote and proceedings of Wednesday, 15th July 2026, page 1, page 2, page 3, page 4, page 5, page 6, page 7, page 8, page 9, page 10, page 11, page 12, page 13, page 14, page 15, page 16, page 17, page 18, page 19, page 20, page 21, yes, page 21.
Mr. Speaker, thank you for the opportunity. Speaker, page 21, question number 822, line 2, first word, delete and insert William. And Speaker, if you may, under urgent question, item 10, the wordings, the manner in which they are typed, some of the alphabets are not clear enough. If you could kindly direct that a second look, they take a second look at it, Speaker. Thank you.
Thank you. Table office, take note. Page 22, page 23. Yes.
Speaker, thank you. 22, item 12, statement. First line, we delete majority after deputy and insert minority. The honorable member for Asqua is the deputy minority leader, not majority leader. Thank you for indulging me.
Very well. You are right. Thank you. Table office, take note. Page 23, 24, 25, 26, and 27. Our members, the vote and proceedings of Wednesday, 15 July 2026, as corrected, is hereby ordered as the true record of proceedings. Yes.
Right, Honorable Speaker, I believe at conclave we consulted and we are...
Yes, let me do the official report of Wednesday, 8th July 2026. Honorable members, the official report of 8th July 2026 is for your correction. Any correction? Honorable members, in the absence of any correction, the official report of Wednesday, 8th July 2026 is also adopted as the true record of proceedings. Yes, Majority Leader. Majority Leader, let me crave your indulgence to announce the presence of students in our midst. Students and other association members in our midst. We have Catholic Organization for Social and Religious Advancement, led by Prosper Agbetome, Accra Arch-President. They are from Ayawaso West, Wagon, the number 39. We also have Harrow International Preparatory School, led by Bless GK. Amenku, a teacher. They are from Okaikwe Central, the number 22. Then we have University of Ghana Public Administration Department, led by Mac Nikwe Ashi, President, and they are from Ayawaso West Wagon, the number 34. Then we have Gospel Church International, led by Minister Isaac Kumi, leader. They are from Domi Kobenya, the number 13. Then we also have Revival International School, led by Achiampong Ata Senior, leader. They are from Swame. They numbered 110. Then we have Precious School Complex, led by Ruben Setoji, leader. They are from Pung Akatamanso, and they numbered 89. Honourable members, on your behalf, I welcome all of them to Parliament of Ghana and urge them to have a fruitful visit. You may kindly resume your seats. Yes, leader.
Mr. Speaker, we agreed in conclave that we'll have, with your indulgence, the Minister for Justice lay papers on behalf of a number of ministers who have papers that have to be laid. So if we can vary the order of business and commence public business and take item number 9.
Yes.
Speaker, we can proceed.
Very well. At commencement of public business, presentation of papers, item number 9. The following papers to be presented. Yes, Majority Leader. Item number 9A by the Minister for Finance.
Yes, so with your indulgence, we will request the Minister for Justice to lay on behalf of the Minister for Finance. If you will indulge us, Mr. Speaker.
Yes.
Mr. Speaker, we don't have a problem with the Attorney General laying the paper. Just know that there is Order 97.3 that we might be able to seek for clarification on this matter.
So, are you reminding him of your right? He is the Attorney General, so he knows your right. Yes. So, item numbered 9A, we are taking I to III. Minister for Justice and Attorney General on behalf of the Minister for Finance.
Credit facility agreements between the governments of the Republic of Ghana, represented by the Ministry of Finance, and the International Development Association of the World Bank Group for an amount of $300 million United States to finance the secondary education transformation for access, relevance, and results for jobs project. Credit facility agreements between the government of the Republic of Ghana, represented by the Ministry of Finance, and the International Development Association of the World Bank Group for an amount of $220 million United States to finance the Harmonizing and Improving Statistics in West Africa project, additional financing. Credit facility agreements between the government of the Republic of Ghana, represented by the Ministry of Finance, and the International Development Association of the World Bank Group for an amount of $500 million United States to finance the Ghana Market Access and Connectivity project.
Honourable members, the item numbered 9AI, II, and III have all been duly presented, and they are referred to the Finance Committee for consideration and report. Item numbered 9B.
Again, Mr. Speaker, with your indulgence, if the Minister for Justice can lay item number 9B on behalf of the Minister for Roads and Highways.
Very well. Yes.
Yes, Mr. Speaker, he can do so.
Very well. Item numbered 9B. Attorney General and Minister for Justice for Minister for Roads and Highways.
Annual statement by the Audit Committee of the Ministry of Roads and Highways for the year ended 31st December 2025. Annual statement by the Audit Committee of the Ghana Highways Authority for the year ended 31st December 2025.
Honourable members, the item numbered 9B, I, and II have all been duly presented, and they are referred to Committee for Roads and Highways for consideration and reports. Item numbered 9C.
Again, Mr. Speaker, with your indulgence, and the agreement of my friends opposite, if we can have the Minister for Justice lay the papers itemized as 9C, IV to XI on behalf of the Minister for Local Government, Chieftaincy, and Religious Affairs. Yes.
It looks as if the numbering is problematic. So, table office, take note. So, item numbered 9C.
Annual statements by the Audit Committee of the Ahafo Southwest District Assembly for the year ended 31st December 2025. Annual statements by the Audit Committee of the Nandom Municipal Assembly for the year ended 31st December 2025. Annual statements by the Audit Committee of the Ketu North Municipal Assembly for the year ended 31st December 2025. Annual statements by the Audit Committee of the Sydney West District Assembly for the year ended 31st December 2025. Annual statements by the Audit Committee of the Offenso Municipal Assembly for the year ended 31st December 2025. Annual statements by the Audit Committee of the Brim South District Assembly for the year ended 31st December 2025. Annual statements by the Audit Committee of the Obuasi East Municipal Assembly for the year ended 31st December 2025. Annual statements by the Audit Committee of the Kintampo South District Assembly for the year ended 31st December 2025.
Honourable members, all the items numbered 9C 1 to 8 have all been duly presented, and they are referred to the Committee on Local Government and Rural Development for consideration and reports. Item numbered 9D.
Same applies to item number 9D.
Yes.
Speaker, there should be no disagreement.
Yes. Attorney General, Minister for Justice, for Minister for Energy and Green Transition.
Annual statement by the Audit Committee of the Tema Oil Refinery for the year ended 31st December 2025. Annual statements by the Audit Committee of the Boss Energies Limited Company for the year ended 31st December 2025. Annual statement by the Audit Committee of the Energy Commission for the year ended 31st December 2025.
Honourable members, the item numbered 9D, III, and III have all been duly presented, and they are referred to a Committee on Energy for consideration and reports. Item numbered 9E.
Annual statement by the Audit Committee of the Rights to Information Commission for the year ended 31st December 2025. Annual statement by the Audit Committee of the Office of the Registrar of Companies for the year ended 31st December 2025. Annual statement by the Audit Committee of the Office of the Attorney General and Minister for Justice for the year ended 31st December 2025.
Honourable members, the items numbered 9E, III, and III have all been duly presented, and they are referred to a committee responsible for constitutional and legal affairs for consideration and report. Item numbered 9F by the chairman of the committee. Yes, Honourable Habib.
Mr. Speaker, I think I've discussed with the majority leader. I'll do that on behalf of the chairperson of the committee.
Yes.
Agreed on this.
Very well. Very well. Item numbered 9F.
Report of the Public Accounts Committee on the report of the Auditor General on the public accounts of Ghana pre-university educational institutions for the financial year ended 31st December 2024. Report of the Public Accounts Committee on the report of the Auditor General on the consolidated statements of foreign exchange receipts and payments of the Bank of Ghana for the year ended 31st December 2024.
Honourable members, the item numbered 9FI and II are duly presented and they are for distribution to honourable members. Item numbered 9G.
Right, Honourable Speaker, with your indulgence and concurrence of colleagues opposite, if I can lay the report on behalf of the Chairman of the Lands and Natural Resources Committee.
Yes.
Yeah, Mr. Speaker, there is no disagreement.
Item numbered 9G.
Report of the Committee on Lands and Natural Resources on the annual statements by the Audit Committee of the Forestry Commission for the years 2022 and 2023. Report of the Committee on Lands and Natural Resources on the annual statements by the Audit Committee of the Minerals Commission for the years 2024. Report of the Committee on Lands and Natural Resources on the annual statements by the Audit Committee of the Office of the Administrator of Sioux Lands for the year 2024.
Remember the reports numbered item 9G, I have all been duly presented and they are for distribution to honourable members. Yes, Majority Leader.
Yeah, Mr. Speaker, thank you for indulging us. We discussed in conclave that we will request that we commence the consideration stage of the tribunal's bill, which is captured as item number 27. And so at page 15, we have the Attorney General and Minister of Justice, who is the sponsor of the bill, and the chairperson of the Constitutional, Legal and Parliamentary Affairs Committee. So we are ready to take the bill with your indulgence.
Yes, before then, we are left with 2 clauses for the defense. Yeah, three clauses. But the indication from the chairman of the committee is that they have dealt with all those clauses, so we should take them. Have we dealt with those clauses? No, we deferred 6, 20, and 27.
Yes, but inadvertently they omitted the
Yes, we can take it.
Okay.
Yes. So have you resolved the 6?
We have done so.
Have you resolved the 20?
Yes, sir.
And then the 27?
All.
So, honourable members, we take it and finish it up, and then we come to the tribunal bill. Yes.
Mr. Speaker, that was not the agreement we had at conclave. Let's stick to our original plan. This one just came up now. So what we can do is to go to consideration stage of the tribunal, and then we can be able, because what the chairman is saying, we haven't even cited it, and neither was it discussed with us. So let's go and start with the tribunal. Then we can come back to it, because they are all at consideration stage anyway.
Because yes, but you see, these 3 clauses were deferred. And the House asked them to go and work on it and report. And then they have worked on it. They are just bringing the report to us.
But, Mr. Speaker, are those amendments being advertised on our order paper?
Yes.
The
it's on page 13. Because they are deferred clauses. We actually consider them and defer them.
All right. Mr. Speaker, if the majority leader is indifferent to that, we don't have a problem. We can do those clauses, and then we can come back to it.
National Defense University Ghana Bill 2026 at consideration stage. So chairman of the committee is the advertised provisions what the committee has agreed upon after the consultation.
Mr. Speaker, the area of contention is 61A and then 61B. We have resolved these two challenges. So
Very
we can
well.
go ahead. Yeah.
So we'll take it one after the other.
Yes, please.
Clause 6. Yes. So clause 6, we've already read it. So chairman, you have the floor. Item numbered 1.
Mr. Speaker, clause 6, amendment proposed. Subclause 1, paragraph DA, delete and insert the following. A chairperson nominated by the president. I so move.
It is for the consideration of the House. Honourable members, any further amendment? Honourable members, the essence is to bring it in line with all other university bills that we have passed. Chairperson appointed, chairperson nominated by the president. Yes? Yes, Honourable Shaibu? Honourable members, I'll put a question. Those in favor say aye. Those against say no. The ayes have it. The proposed amendment is ordered to stand part of the bill. Chairman of the committee, item II.
Mr. Speaker, subclause 6, amendment proposed, subclause 1, paragraph F, delete. We are deleting the chief director of the ministry responsible for defense from the membership of the council. I so move.
It is for the consideration of the House. All members, any further amendment? In the absence of any further amendment, I'll put a question. Those in favor say aye. Those in favor say aye. Those against say no. The ayes have it. Clause 6 is ordered to stand part. The proposed amendment to clause 6 is ordered to stand part of the bill. Chairman, proposed amendment III.
Amendment proposed, subclause 1, paragraph G, delete and insert the following as advertised on today's order paper. I so move.
Honourable members, is for the consideration of the House. Any further proposal to amend? Yes.
Mr. Speaker, a further proposed amendment to GIII to qualify who represents the Ghana Tertiary Education Commission. So not below the rank of a director. So just as we have for Ministry responsible for defense under I, Ministry responsible for education under II, under GTEC, Ghana Tertiary Education Commission, not below the rank of a director nominated by the Ghana Tertiary Education Commission. I so submit, Mr. Speaker.
Why are you saying so in view of IV?
Speaker, the reason is
and then V as well. You know of their ranking? So probably it means they are just looking for a representative from there.
Speaker, GTEC.
Because if that amendment is carried and we have to, the fourth one, civilian academic staff of the constituent colleges nominated by the civilian academic staff of the constituent colleges. This one, they didn't state any rank. I believe these ones, when it is coming to ministries, then they indicate ranks. That's the sense I'm gathering here. And if you look at civilian non-academic staff of the constituent college nominated by the civilian non-academic staff of the constituent college, they didn't indicate any rank. Yes?
Mr. Speaker, at committee, in fact, when the GTEC was represented, they actually accepted the position taken by my colleague that the rep of the Ghana Tertiary Education Commission should not be below the rank of director. So if you look at our report, that is what is actually captured. So I want to think that the ranking system is well respected within the Ghana Tertiary Education Commission itself, which is why...
Very well. Then I'll put a question on the proposed amendment by the chairman of the committee as further directed. Chairman, are you in agreement?
Mr. Speaker, I have no objection.
Very well. So it's for the consideration of the House. Any further amendment? I'll put a question. Those in favor of the proposed amendment by the chairman of the committee to clause 6, as in item numbered II, as further... Yes.
Thank you, Mr. Speaker. Further amendment to III, clause 6. Mr. Speaker, this is an educational institution, and as such, we cannot have only one student representative on the council. This is an institution that is made up of both graduate and undergraduate students, and as such, just having one student nominated by the SRC is not something that we will advise. If you look at the current renditions and the KNUST bill, which we keep referring to, we have 2 student reps, one by the SRC, which is undergraduate, and one also by the Graduate Students Association. So, by graduate, make it specific because there could be other graduate students associations. So, Mr. Speaker, I propose that we include additional sub-clause for G, where we will have one student rep nominated by the Graduate Students Association. Then, of course, we can also amend 6 VII to include undergraduate students, as is captured in the KNUST.
Yes,
Act.
Chairman of the committee.
Mr. Speaker, we discussed this at length at the committee level and finally settled on SRC being putting up one person to be on the council. That was the decision at the committee level. But I leave it to you and the House to decide.
Yes, but the VII is even saying students of the university. It's plural form. So he is asking how many. It should be 2 students.
Mr. Speaker, if I listen to him carefully, he's asking that probably a graduate student be added.
No,
that is what
he is first saying that the students should be 2 representing the SRC. Then the third one is additional clause to make provision for graduate students.
And Mr. Speaker, respectfully, we can go with the provision as is in the KNUST and all the other universities. We have one for the undergraduate by the SRC, then one for the graduate students. So we have 2 reps, and it will be unfair for an educational institution like this to have just one student representative representing students.
Yes, Honorable James Agalga.
Mr. Speaker, I think for once I would support my colleague. For once, yes. Mr. Speaker,
Honourable members, I'll put a question on his proposed amendment to add 2 to VII to mean 2 students of the university nominated by the Student Representative Council. And then, yes. Yes, it's good you are drawing my attention to it. In this case, if you look at the opening phrase, it says one representative from all. It says one representative, the opening phrase.
Yeah, exactly so, Mr. Speaker. That is why I'm asking if we want
one representative each of the following.
Yeah. So we can have one, we can amend.
Are you part of the committee?
Yes,
What was agreed upon at the committee meeting?
We discussed this at length, Mr. Speaker, for the sake of the students. And if we couldn't agree on it, it's good that I come to the plenary to advocate for the student for whom this university is being built.
No, I'm just asking that what have you agreed upon at the committee? You are entitled to depart from the committee's decision. The House wants to know what the committee has agreed upon.
Yeah, so the committee agreed that one student nominated by the SRC, but my counter proposal or amendment is that one, we should amend VII to include undergraduate
so then,
students.
In that case, I would push for the second amendment that you are making, that will make provision for a graduate student. And that would then make it 2.
I agree. So
yes.
So
there will be additional clause.
So I propose
that is VIII.
Yeah.
Yes. So propose a rendition.
Thank you, Mr. Speaker. So I do propose that additional clause be added to clause 6, the subclause G, to VIII, and to read one student of the Graduate Association of the university.
All members, this is for the consideration of the House. I will then put question on the proposed amendment by the chairman of the committee as variously amended. Those in favor say aye. Those against say no. The ayes have it. The proposed amendment by Dr. Cheya Samoa and Honorable Shaibu, as well as the chairman of the committee, are all ordered to stand part of the bill. Yes, Chairman, item IV.
Mr. Speaker, amendment proposed. Subclause 1, paragraph I, line 1, delete 4 and insert 3. I so move.
All members, the proposed amendment is for your consideration. Any further amendment? In the absence of any further amendment, I'll put a question. Those in favor say aye. Those against say no. The ayes have it. The proposed amendment to clause 6 as in IV is ordered to stand part of the bill. I'll then put a question on entire clause 6 as variously amended. Those in favor say aye. Those against say no. All members, clause 6 as variously amended is ordered to stand part of the bill. Chairman, clause 20. Chairman, clause 20.
Mr. Speaker, clause 20, amendment proposed. Subclause 1, after paragraph C, insert the following new paragraph, deans. I so move.
It is for the consideration of the House. All members, any further amendment? This is simple. I'll put a question. Those in favor say aye. Those against say no. The ayes have it. The proposed amendment to clause 20 is ordered to stand part of the bill. Chairman VI.
Mr. Speaker, amendment proposed. Subclause 1, paragraph E, delete professional and insert professorial. I so move.
I'll put a question. Those in favor say aye. Those against say no. The ayes have it. The proposed amendment to clause 20 is ordered to stand part of the bill. Chairman VII.
Mr. Speaker, amendment proposed. Subclause 1, paragraph H, delete. I so move.
It is for the consideration of the House. All members, any further amendment? In the absence of any further amendment, I'll put a question. Those in favor say aye. Those against say no. The ayes have it. The proposed amendment to clause 20 is ordered to stand part of the bill. Now, I'll put a question to entire clause 20 in the absence of any further amendment. Those in favor of clause 20 as variously amended, standing part of the bill, say aye. Those against say no. The ayes have it. Clause 20 as variously amended is ordered to stand part of the bill. Clause 27.
Clause 27, Mr. Speaker, yesterday we deferred it.
Yes.
But unfortunately,
so, turn to other paper addendum.
I'm yet to receive a copy.
So use the proposed amendment that you have. Oh.
Mr. Speaker, amendment proposed. Clause 27, paragraph C and D, delete. I so move.
All members, let's take it one after the other. Let's deal with paragraph C. So, all members, the proposed amendment is to delete paragraph C of clause 27. It is for the consideration of the House.
Yes.
Any further amendment? In the absence of any further amendment, I'll put a question. Those in favor say aye. Those against say no. The ayes have it. Paragraph C of clause 27 is ordered to be deleted. Now, Chairman.
Mr. Speaker, amendment proposed, paragraph D, delete. I so move.
All members, the proposal is to delete paragraph D of clause 27. Is there any further amendment? In the absence of any further amendment, I'll put a question. Those in favor say aye. Those against say no. The ayes have it. Paragraph D is ordered to be deleted. Now, I'll put a question to entire clause 27. As many as are in favor say aye. Those against say no. The ayes have it. Paragraph 27, as variously amended, is ordered to stand part of the bill. Long title.
An act to establish the National Defense University, Ghana, and to provide for related matters.
Chairman of the committee.
Mr. Speaker, there is no proposed amendment.
It is for the consideration of the House. Honorable members, any proposed amendment to the long title? Honorable members, in the absence of any proposed amendment to the long title, I'll put a question. As many as are in favor of the long title, standing part of the bill, say aye. Those against say no. Honorable members, the ayes have it. And that brings us to the end of the consideration stage of the Defense University Ghana Bill 2026. Yes, but he will come back. Our members, we then move to the tribunal bill. So the tribunal bill 2026 is at consideration stage. Honourable members, clause 1.
Application of this act.
Chairman of the committee.
Mr. Speaker, clause 1, amendment proposed. Line 2, delete this act and insert the Constitution and this act. I so move, Mr. Speaker.
Honourable members, the proposed amendment is for the consideration of the House. Any further amendment? I'll put a question. Those in favor of the proposed amendment by the chairman of the committee say aye. Those against say no. The ayes have it. The proposed amendment to clause 1 of the bill is ordered to stand part of the bill. And I'll put a question on the entire clause 1 in the absence of any further amendment. Those in favor say aye. Those in favor say aye. Those against say no. The ayes have it. Clause 1, as amended, is ordered to stand part of the bill. Clause 2.
Object of this act.
Chairman of the committee.
Speaker, no proposed amendment, please.
It is for the consideration of the House. Honourable members, any proposed amendment? In the absence of any proposed amendment, I'll put a question to clause 2. Those in favor say aye. Those against say no. The ayes have it. Clause 2 is ordered to stand part of the bill.
Guiding principles.
Chairman of the committee.
Speaker, no proposed amendment under guiding principles.
It is for the consideration of the House. Honourable members, any proposed amendment? In the absence of any proposed amendment, I'll put a question. Those in favor of clause 3 standing part of the bill say aye. Those against say no. The ayes have it. Clause 3 is ordered to stand part of the bill. Clause 4.
Establishment of the tribunal system.
Chairman of the committee.
Speaker, no proposed amendment.
It is for the consideration of the House. Honourable members, any proposed amendment to clause 4? I'll put a question. Those in favor say aye. Those against say no. The ayes have it. Clause 4 is ordered to stand part of the bill. Clause 5.
Administration of tribunals.
Chairman of the committee.
Speaker, clause 5, amendment proposed. Head note, delete tribunals and insert tribunal. I so move, Mr. Speaker.
The proposed amendment is for the consideration of the House. Yes, Honourable Minority Leader.
Speaker, I'm sorry to take you back to clause 4, if you would indulge me.
Well, I'll reverse and indulge you.
I'm grateful. Speaker, with respect, I move that the entire clause 4 be deleted. Mr. Speaker, my reason is very simple, Mr. Speaker. I would take us to Article 125. Mr. Speaker, clause 4 refers to clause 2 of Article, it refers to clause 2 of Article 125 and clause 1 of Article 126. Mr. Speaker, clause 2 of Article 125 reads, citizens may exercise popular participation in the administration of justice through the institution of public and customary tribunals and the jury and assessor systems. And if you go to 126 clause 1, Mr. Speaker, what the provision is saying is that because of the provision of such lower courts or tribunals as Parliament may by law establish. So they are rooting that provision from this. Mr. Speaker, let's go to 142 itself.
Are you talking about Article 142?
Yes, Mr. Speaker, I'm making reference to all the constitutional provisions that have been cited in the clause that I'm seeking to
Very well.
get deleted. Mr. Speaker, if you go to 142, where the establishment of regional tribunals have been provided for as the Chief Justice may determine. Mr. Speaker, clearly for many years now, we all know that the justice system that we have in this country has worked. However, Mr. Speaker, the disagreement we may have with certain pronouncements of certain judges. Mr. Speaker, like this morning, my Lord Atuguba, all of us were there when he raised concerns about even certain pronouncements of our courts. Mr. Speaker, that does not mean that we create some parallel structures that we call it a justice system. Mr. Speaker,
Honourable members, let's take it one after
provisions in
the
the
other.
Constitution,
So let me indulge him.
the
Yes,
provisions in the
Honourable.
Constitution were qualified. We cannot be interpreting constitutional provisions in a disjointive manner. Then, in so doing, we create chaos in the system. Mr. Speaker, how on earth do we create a new system to compete with a known system just because somewhere in the Constitution certain pronouncements are made? So we should bring an enactment to govern it. Is that what we are doing? A district tribunal, a regional tribunal, to do what? Mr. Speaker, a tribunal to do what? To compete with a high court? Or to compete with a court of appeal? Or there's going to be a Supreme Tribunal Council? Because if you start this way, what you are going to do is now you are now going to have another Supreme Tribunal Council, which is going to now, you tell us that the Constitution talked about it, so that is also equivalent of a Supreme Court. That is what you are trying to do. Mr. Speaker, I do not think that we need this provision. The entire clause 4 be deleted. Mr. Speaker, the entire clause 4 be deleted. What kind of chaos are we setting? Are we introducing? In the name of reset, you have a district court, you have a circuit court, you have a high court, a court of appeal, you have a judiciary architecture that is not broken. Is it the creation of tribunal system?
No.
Mr. Speaker, you want a Chobwe court. That is what you want. Where justice delivery cannot be guaranteed. Populism, Mr. Speaker, we don't need this.
Honourable
We don't
Minority
need this.
Leader, are we doing second
Mr.
consideration
Speaker,
or
I'm not.
second
I'm
reading?
justifying, Mr. Speaker, I'm not doing that.
Second reading
Mr.
of the
Speaker, I am
bill.
not doing that. Whenever you propose an amendment, you must justify. That's all I'm doing. I cannot bring a lame application before you, knowing Mr. Speaker. Mr. Speaker would want to find out the grounds upon which I mount my application. I am only, Mr. Speaker, I am only mounting my application on solid grounds, and I need to persuade my colleagues. Mr. Speaker, we don't do this at consideration stage. You listen to your colleague. There's nothing like point of order when it comes to consideration stage. There's no point of order. Colleagues must listen. When I finish, you bring your counter argument. This is a persuasive point in our deliberation. I want to carry you along. That,
Okay,
Mr.
so
Speaker, we already have an unbroken...
I want you to carry all of us along.
Very
You
well.
make reference to 126. Look at 126A, I. What do you make out of it?
Very well. Mr. Speaker, let me read it. Let me read it for you. Mr. Speaker, you said 126 I. Which of them specifically, Mr. Speaker?
126 I.
All of them. What do I make of all of them?
The I just says that the Superior Court of Judicature comprise the III state, the High Court, and regional tribunals.
Mr. Speaker, what I am saying, yes, so, Mr. Speaker, what I am saying, that the fact that this provision is there must not lead to any interpretation in isolation. Look at the constitutional, the judicial architecture as a whole. Mr. Speaker, look at it as a whole. Why would you need a tribunal? You need a tribunal to do what? Mr. Speaker, I am saying.
Okay,
Speaker,
you also make reference to 142. This consideration stage.
Yes.
Can we look at the 142 together?
Yeah, Mr. Speaker, we are doing so. Yes.
So the 142 says that there shall be established in each region of Ghana such regional tribunal as the Chief Justice may determine. Thus, putting these two provisions together, does the Constitution makes provision for establishment of regional tribunals?
Mr. Speaker, the Constitution is telling Parliament to make a determination. The Constitution says Parliament, as Parliament may determine. Mr. Speaker, and I'm saying that this Parliament must know that the justice architecture we have is not a broken architecture. It's not. It is not a broken one. We have a district court. We have a circuit court. We have a high court. We have a court of appeal and the Supreme Court. All these years, we know that during the transition into democracy, there existed some populist justice system which found its way into the Constitution. Is the reason why the framers of the Constitution indicated that Parliament may legislate.
Minority Leader.
Yes, Mr. Speaker.
Does it mean the framers of the Constitution do not know that we have district courts, we have circuit court, we have high court, we have court of appeal and Supreme Court before stating regional tribunal?
Mr. Speaker, I am making my political argument, and the political argument I am making, interlacing it with the law and governance. Mr. Speaker, we have to test the efficacy of the governance architecture. That is the argument I'm making. And I'm saying that the framers of the Constitution did not impose this on us as a parliament. They have never imposed anything, so nobody should take solace in the Constitution and say that it is in the Constitution. No. They say Parliament may. Because, Mr. Speaker, we have to be careful creating an analogous justice system. We have to be careful. We have to be careful. Because, Mr. Speaker, it leads to some uncertainty. Now you are bringing a whole legislation for this, Mr. Speaker, instead of improving on the structures and resourcing the courts, help the court to be fully digitalized, help the court to have the necessary tools to administer justice. Then you say you are creating another bureaucracy to bring a new tribunal. Mr. Speaker, we know of what the tribunals did. The dark days of Ghana, we are revisiting it on Ghanaians in this democracy? No. Mr. Speaker, the Attorney General himself is a human rights practitioner. We know his record at the court. A respected human rights activist, a respected human rights lawyer. He is introducing this tribunal system. that is going to destroy the justice delivery system. Mr. Speaker, we have to be careful. Is it going to be in charge of civil matters or criminal matters? Mr. Speaker, I am asking rhetorically. Respected Leonard, you must listen to me. You have your opportunity to have a bite. This is unfair. Respected Leonard Attorney General, first gentleman at the bar. This approach is wrong. This is wrong. You have your bite.
Honorable Minority Leader.
In the mic.
Honorable
There's
Minority
no point
Leader.
of order. Mr. Speaker,
Honorable
let him
Minority
sit down.
Leader.
It's wrong.
Honorable Attorney General.
And I'm
Please,
your senior in
both
this chamber.
of you should resume your seats.
I'm your senior.
Honorable,
I agree, but I'm your senior here. And I'm your senior here.
Both of
And
you
I'm your
should
senior here.
resume
But you are
your seats.
introducing chaos. That is what the tribunal will do. What you are doing is what the tribunal will do. They should let us speak.
Both of you resume your seats.
The tribunal system. This is the tribunal system. This is the tribunal
Honorable
system.
Minority Leader,
Tribunal
Attorney
system.
General, both of you should resume your
Tribunal
seats.
system of justice. Tribunal system of justice. That's what you are practicing.
Honorable members, the truth must be told. Honorable members, order. Honorable members, the truth must be told. The truth must be told. Please, at the consideration stage of a bill, we don't debate as if we are debating the second reading of a bill. The debate of second reading has been concluded. If you move amendment, I do not think the justification for your amendment should even go beyond 2 minutes. If we were to do a consideration stage as if we are debating the second reading, then I believe strongly we cannot go through a consideration stage of a bill. So we need to be guided by our standing orders. The rule is that you move your amendment, you justified it, and then we put the question and let the House take decision. So please, let's not reduce a consideration stage of a bill to a second reading stage of a bill. With all due respect, let's do the right thing. So, how many minutes more do you need to finish?
Mr. Speaker, this is a subtle attempt to frustrate advocacy on the House floor. Mr. Speaker, this is a serious constitutional matter, and I speak for my side. There cannot be a subtle way that when I'm justifying my application, I'll be told that there's supposed to be 2 minutes, has to be brief. Mr. Speaker, this is a government that is seeking to use a legislation to create an analogous justice system.
Honorable Minority Leader, your amendment must be for the consideration of the House.
Mr. Speaker, it is so. I need to carry them along with respect, sir. I need to carry them along. So, Mr. Speaker, let me finish my argument. I will finish it in all humility, sir. Mr. Speaker, I contend that creating this new tribunal system by this provision, Mr. Speaker, will bring chaos to the justice delivery system we have in our country. Mr. Speaker, this is populism. We need clarity. Justice must not just be done, must be seen to be done. Mr. Speaker, I remember the famous case of Tagore and Issa Abbas, where the respected Dr. Dominic Ayeni took the matter up at Court of Appeal. These were individuals who were convicted. And at the Court of Appeal, his argument was that a man may not just be convicted because of his own words. That is populism. He argued. He said every element of a crime must be proven. Lead evidence of probative value. That was the argument of the respected Dr. Ayeni. It was because we had a clarity, certainty in the law. We had a court of appeal, well properly constituted. Today, you want to have a tribunal? A tribunal? Populism, Choboy justice. Choboy justice. Mr. Speaker, Choboy justice, where people will be sent and people will be thrown into jail. Mr. Speaker, I will not sit here as a minority leader and allow this provision to stand. I move that this provision be deleted. Mr. Speaker, I so move.
Honourable members, the proposed amendment is for the consideration of the House. Now, let me hear the Attorney General and Minister for Justice.
Right Honourable Speaker, I think you brought a lot of clarity to this issue when you drew the attention of the Honourable Minority Leader to the fact that at the consideration stage, we are not supposed to spark debate as if we are at the second reading of the bill. You are to justify each amendment that you have proposed and to persuade all of us to vote in favor of your amendment. Now, Right Honourable Speaker, he has said a lot of misleading things. These things are textually incorrect as far as the Constitution is concerned, because as you yourself drew his attention to the provision in Article 126 of the Constitution and 142, but let's start with 126. It provides an integrated judicial system that includes regional tribunals, and that also includes such lower courts or tribunals as Parliament may by law establish. And Mr. Speaker, this is exactly what we are doing. In terms of the regional tribunals, what we are doing is just simply amplifying the provisions of the Constitution in 126 and 124. In terms of the district tribunal, what we are simply doing is implementing 126 by creating a lower tribunal that will deal with criminal matters that have been specified in the bill, including those of illegal mining. So, Mr. Speaker, we are not creating a parallel justice system. We are simply amplifying what is provided for in the Constitution. Also, I'm happy that he says that it's a political argument that he's making and not a legal argument. You are making a political argument because the argument that he has made, please.
But Honourable Minority Leader, you know that when you get up and you want to speak, you catch the eye of the speaker. So why is this thing happening? I didn't recognize him. I did never recognize him. This is the only occasion that I recognize the Attorney General. This is the only occasion I recognize the Attorney General. You understand? So, the House must be orderly. The House needs to be orderly. Yes, Honourable Attorney General, you have the floor.
Yes. Right, Honourable Speaker. Let's even admit that it was a political legal argument. It is still at that level very unfounded. It is very unfounded because we are not creating a parallel system of justice. We are not creating a parallel system, a system of justice that will compete with the existing court system. In fact, constitutionally and textually, as I have pointed out, and historically, the tribunal system has been an integral part of our fourth Republican judiciary since 1993. So we are not creating any system of justice that will compete with the existing system, because the existing system, includes the traditional system. The tribunal system. So, Mr. Speaker, I think, Mr. Speaker, I think that the amendment proposed is unfounded and should be rejected by the House. I'm not moving.
Honourable members, I will then put a question on the proposed amendment. Yes.
Mr. Speaker. Oh, okay.
Yes.
Thank you, Right Honourable Speaker. Mr. Speaker, I rise to support the application of the Honourable Minority Leader, Mr. Speaker, that the entire Clause 4 of the bill be deleted from the bill, Mr. Speaker. And indeed, Clause 4 goes to the gravamen of the bill, the establishment of the tribunal system, Mr. Speaker, as this bill seeks to promulgate and establish. Mr. Speaker, I say so because when you look at Article 126 of our national constitution, as has been variously referred to, and which provides for, Mr. Speaker, the establishment of lower courts or tribunals as Parliament may by law establish. Mr. Speaker, so legally the bill is properly grounded. However, Mr. Speaker, laws are to be established within a constitutional and democratic system in a way, Mr. Speaker, that will advance the ends of this constitution, the 1992 constitution, in its totality. And in its totality being, Mr. Speaker, that Ghana, as a democratic and constitutional state, should have a judicial system which is fit for purpose, which indeed, Mr. Speaker, will promote our democratic aspirations as a country, which is why, Mr. Speaker, the minority leader has rightly argued that Clause 4 of the bill be deleted. And in fact, Mr. Speaker, I will take it a step further. Mr. Speaker, that the ongoing efforts to review our national constitution should actually consider amending Article 126 to take out Article 126(1)(b) and make it impossible for this House even to consider Clause 4 of this bill in the first place. To mean, Mr. Speaker, that we should not even have a tribunal system at all, which is why Clause 4 should be abolished. And Mr. Speaker, what is the reason? In all democratic societies in the world, and by that I refer with emphasis, well-established democratic systems. Mr. Speaker, the judicial system is well-structured and established. District courts, if you want community courts, you have it. Circuit courts, High Court, Court of Appeal, Supreme Court. If you lose at the Supreme Court, Mr. Speaker, you have a right of review. Mr. Speaker, I'm yet to be told in which established democratic dispensation in the world, whether in the Westminster system or the American system or North American system or our contemporaries in Africa like Kenya, Nigeria or other places where they have a high court and have a regional tribunal and have a chairman of the tribunal and have two appointees more or less by the establishment, and that exercises jurisdiction which is almost coterminous to the High Court. Let them tell us today, Mr. Speaker. There's none like that. And that is why the minority is making the case that let us examine these clauses in its totality, in its totality, as we are dealing with a constitutional democratic country such as ours has been since 1993 to date. Mr. Speaker, let me conclude by urging on our friends from the majority side and urging on the respected Honorable Attorney General that sometimes, Mr. Speaker, when you sit on the right-hand side of the Speaker and you are arguing for the enactment of laws, you look at it with the greatest of respect, and I say so with a lot of respect, from a narrower view, in terms of you seated on the right-hand side of the Speaker. But you make laws, Mr. Speaker, contemplating when you're on the left-hand side of the Speaker and the law has been enacted. Mr. Speaker, I don't I shudder to refer this House to the enactment of willfully causing financial loss to the state. We are reliably informed, and Hansard will bear me out, that at the time the law was being enacted, some elements seated in the on the right-hand side of the Speaker cautioned about the nature of that law. And we all know how this law has been applied in our country. So, Speaker, this country, I want to conclude. We've had a district court, we've had a circuit court, we've had high court, we've had court of appeal, we've had Supreme Court. Our democracy has functioned and functioned well. If it's the question of dealing with backlog of cases, strengthen the judicial system, build more courts, as President Akufo-Addo built more than 100 courts, recruit more staff, recruit more lawyers, strengthen the institution. Do not duplicate institutions. Let us rather strengthen the judicial system as we have it, Mr. Speaker. And therefore, we are inviting our friends to join us to support the minority leader's application for clause 4 of the bill to be deleted. And as I have added, for this whole concept of the tribunal system to be jettisoned. Because, Mr. Speaker, if you look at it properly, it is alien to the aspirations of a constitutional and democratic society such as ours, as we practice in this Fourth Republic. The British Westminster system will bear me out. The American system will bear me out. All established democracies will bear me out. Mr. Speaker, we do not want a tribunal system. It shouldn't be an avenue to fast-track justice. Mr. Speaker, one innocent man jailed, Mr. Speaker, is worse than 99 guilty people freed. And it's been said, do not let us have any kangaroo court system in our country. What we have is fit for purpose. It's been so throughout this Fourth Republic. I so submit, and therefore, Mr. Speaker, let's support the minority leader's application to have this clause deleted. Thank you, Mr. Speaker.
Thank you, Mr. Speaker. Mr. Speaker, I rise in support of the proposal by the minority leader that the entire clause 4, establishment of the of the tribunal system, be deleted. Mr. Speaker, I say so because listening to the argument in the chamber, it is very clear that the establishment of the tribunal will not address anything new that the existing system cannot address. What is the tribunal coming to address that our district, our magistrate court, our circuit court, our high court, the court of appeal and the Supreme Court, what will they address that our current systems cannot address it? So, Mr. Speaker, unless it is the case that these courts are going to be established, Attorney General, unless it is the case that you want to establish this tribunal to use it for political persecution, at the regional level, you use the court to intimidate and jail political opponents. And at the district level, I said unless it is the case, because the current system that you have, if something is not broken, why fix it? If something, your court system, if it is the case that you have backlog of questions, and even if you go to cases, Mr. Speaker, and even if you go to, if you move further to clause 5, 7, and 8, and you even look at the people who are supposed to be appointed to be the chairperson and members of the tribunal, it is clear that it is job for the voice. That you are creating this one to say if somebody is qualified to be at a high court, being a member, then you appoint your party lawyers to be in there, intimidate people, put them before the tribunal, and get them jailed as quick as you can be. It can be. So, Attorney General, I am yet to be convinced that the tribunal you seek to establish will do something different that our court system is not doing. I am yet to be convinced on that note. And Attorney General, this is not the first time. You remember previously our senior Tachu, he said this is an illegality. He argued this to the Supreme Court, that tribunals are illegal. And for that matter, for you to now seek to introduce it at this moment, Mr. Speaker, it is addressing nothing unless you want to intimidate political opponents and rush cases, send it to tribunal, put your own panel, jail them for political reasons.
Honorable Habib, let me draw your attention to the fact that Chachu Chikata never went to court to argue against the tribunal system. He argued against the fast-track high court.
Okay,
so he's
Mr.
not
Speaker,
here to
if that
defend
is the
himself.
case, I have
But
withdrawn.
this is a house of record. This is a house of record.
So, Mr. Speaker, if it is the case that he did not, I withdraw that part of it. But based on your correction, if the learned Tatuchikata can argue that the fast-track High Court was even an illegality, why more talk about a tribunal then? How more less
Have
than a
they
tribunal?
brought the fast-track High
If
Court
the
to
fast-track High
Parliament
Court
to
was
be
an
established?
illegality and it was done for political persecution, how more less than a tribunal? Then that means that tribunals are just there to put political opponents and jail them, rush the cases, put your 3 people. Because you are saying if you look at clause 5(6), is it the case that you don't have qualified judges? Why not strengthen the institution of your courts? Why not employ more judges, employ more court workers so that you'll be able to? So, Mr. Speaker, I also support the clause 4 that it should be deleted. The entire clause 4 should be deleted. And Mr. Speaker,
Thank you
and I don't
very
even
much.
think at this point, Mr. Speaker, I want to draw your attention that at this point, if we move further without taking a decision on clause 4, then it would be a great disservice to whatever we have to do with the bill. So the Attorney General have 2 options. Either allow clause 4 to be deleted or humbly withdraw this bill, and then we will all be free. I thank you, Mr. Speaker.
Yes, Honorable Majority Leader. I think we have heard the House a lot on the proposed amendment to clause 4. So please, will you allow me to moderate the House? I think that is my responsibility as a Speaker of the House. So you have taken a position and 3-4 people argue in favor. Some argued against. What do? We put the question and let the House take decision in moderating the House. Do you understand? So you have spoken, Abu has spoken, Habib has spoken. So if I want to hear the Attorney General and conclude on the issue and let the House take decision, what is my offense? You make the proposal, you have defended it. So it is for the consideration of the House. So for the House to consider it, I allow you to speak. I must allow, Attorney General was the only one who spoke from my side here. And I'm now giving the opportunity to the leader to also speak and let the House take decision.
I'm not opposed to your decision to moderate the House in a manner that would ensure peace. However, my role is to guide. Mr. Speaker, you realize that this is an important constitutional matter that touches on an arm of government, an institution of state, the judiciary. Mr. Speaker, that side, my colleagues to your right, they have decided so far to only allow the Attorney General to respond to the amendment. On my side,
please, they cannot decide
Mr. Speaker,
person to allow to speak.
Mr. Speaker, for want of a better word, some of these things, let it slide. All I'm saying is that so far, it is only the learned Attorney General who has gotten up to oppose me. So far, we've only had one opposition to my application.
Yes.
Good. And I'm saying that apart from those who have spoken in support of the application or the motion for clause 4 to be deleted, I have the list from my side because we prepared before coming. We prepared. Let me finish, Mr. Speaker.
Yes.
Let me finish. Then you make your ruling so that we can also take a decision.
Very
Please,
well.
I don't want to have a back and forth.
Very well. Very
Thank you. For us, because we have a position on this, we prepared our colleague Hassan Tampoli, who is the vice chair of the Constitution and Legal Affairs Committee of the House. We have Honorable Bafo Ewa, who is a senior member at the bar and a member of the Constitution and Legal Affairs Committee. Mr. Speaker, we would want to plead with the chair that they be heard, because this is amendment. And at consideration stage, members, Mr. Speaker, members must not be stampeded, because if it's all about votes, Mr. Speaker, if it's all about votes, this side will never win a vote. And we are not here to win a vote. We are here to enrich democracy. We must be heard. If we always rush, take a decision, Mr. Speaker, I am pleading with you. I would always assist you and, give you every respect. But please, I have my side. We are just 87. If you don't come to our rescue, who else will come to our rescue? Mr. Speaker, this is a Chobwe law. So please, my respected colleague, the majority leader, a man in whom I'm well pleased. At this point. Mr. Speaker, in spite of all the mischief he perpetrates against me, I know he's doing his job. So if he gives me uppercut, I let it go. I can't take it personal. But I know he's a true gentleman who believes in the fidelity of the law, including the Attorney General himself. The many cases he's done at the bar, these cases have been reported. He shouldn't dilute it with politics, Learned Attorney General. Learned Attorney General, we know your records at the bar. We've cited your cases in our court. We know. So, Mr. Speaker, please, my three colleagues would want to also have a bite on my application. And after that, if the other side, they see no evil, hear no evil, we know. But, you can never tell tomorrow. This tribunal that will not have judges, but chairman, member, if you allow it to stay, and one day you come back into opposition, and some rogues find their way, what they will do in this country, Mr. Speaker, to conclude, let's be careful, like what Justice Atigya told us this morning. Let's be careful. It may be your policy, but anybody who is not a proper judge is given judicial power at the district level, at the regional level. We know at that level things that happen. Mr. Speaker, sometimes civil litigation ends up in criminal matters. Let's be careful, colleagues in leadership, colleagues in politics. Let's be careful. Mr. Speaker, I will end it here. Please, after hearing the majority leader, please permit my colleagues to speak.
Honorable members, I still maintain that consideration stage is not a second reading of a bill. Consideration stage is not a second reading of the bill. I have listened, though I wasn't here during the second reading of the bill. What we are doing was not different from the debate that I have listened to at the second reading stage. Because at the second reading stage, you can submit that the bill should not be passed. You can question the mischief that the bill is seeking to cure. You can question the principle underpinning the bill. But if you are moving an amendment on a clause, the debate of the second reading is over. The House have taken a decision to progress with the bill. That is why we are at the consideration stage. I've also been in this House for some time. We never had a speaking list at the consideration stage of a bill. This is the first time. You understand? So I do not like what is happening. Yes. Yes.
Thank you. Thank you very much, Mr. Speaker. I can understand that at this stage, the debate will be heated because Clause 4 is at the very heart of this bill. Clause 4 is at the very heart of this bill. And the truth also is, as Speaker indicated, the arguments against Clause 4 turns out to also be the principle based on which there is opposition to the bill. So the two arguments are the same, which is any argument against this bill will sound like the arguments that occurred during the second reading when we analyze the principles of the bill. And so when I hear the Honorable Jinapo, I hear a repetition of what he said on the day when we were having the debate on the principle of the bill. I wasn't here when the minority leader spoke, but I would be surprised if his argument was materially different from what Honorable Jinapo also argued. Essentially the same. Two things will happen. I think that it is good to have a healthy debate, but it is good also that when people are going to speak, they must be saying something different. But just repeating what others have said sometimes can be really very, boring. So let us also be guided by the Speaker in terms of how we manage our time in the chamber. But Mr. Speaker, let me state once again that I have heard Honorable Jinapo, and he is arguing that we should go for an amendment of the Constitution in order that we don't have anything to do with tribunals. Until we achieve that amendment, we have no other way than to respect what the Constitution says. And the Constitution says that we should have regional tribunals. The Constitution says we shall have regional tribunals. So if we are going to honor and respect our Constitution, if the Constitution says we should have regional tribunals, this Parliament cannot accept the existence of a Parliament and yet reject the existence of regional tribunals. That would be a contradictory argument. Because we have an oath which enjoins us to be committed to the Constitution and whatever the Constitution says, irrespective of our personal views about the Constitution. The Constitution says that there shall be regional tribunals. There shall be regional tribunals until the review takes place and Ghanaians vote amending the Constitution. There shall be regional tribunals. There shall be regional tribunals. So let us have regional tribunals, and when there's a constitutional review and Ghanaians say they don't want regional tribunals, then as a matter of fact, regional tribunals cease to exist upon the passage of a new constitution which outlaws regional tribunals. And I also listened to my brother, Honorable Jinapo, and he says that in every civilized democracy, you don't have a tribunal system. But you see, you misunderstand a tribunal system. What is the tribunal system? In this tribunal system, we have one chairperson and two other members. And the principle behind the tribunal system is not any different or does not radically depart from the principle underpinning the jury trial system. It doesn't depart materially from trial by jury because it is trial by your peers. Indeed, a tribunal system is far better
than a jury system, because in this instance, you have the judge, the chairperson whose qualifications are the same as a High Court judge. The chairperson, the qualifications for a chairperson are the same as a High Court judge. Indeed, the law we are passing makes it possible for all the 3 members of the tribunal to be lawyers. The law makes it possible, because it doesn't say 1 lawyer and then 2 other non-lawyers. It doesn't say so. It says a chairperson and 2 other persons. And then it defines a minimum qualification based on education and etc. But it can go up to a PhD holder. It can go up to a lawyer of 10 years standing at the bar, of 15 years standing at the bar, of 20 years standing at the bar. Indeed, more eligible than many of those who are sitting as High Court judges today or Circuit Court judges today. So this is indeed far better than even a jury trial of your peers, because in this instance, the regional tribunal is made up of a chairperson who must have the same qualifications as a High Court judge. So what's your problem? Why do you think that a High Court judge who has the same qualifications as a person who is a regional tribunal chairperson will do better than a regional tribunal chairperson? They all have the same qualifications. They are all appointed through the same process. Through the same process. Why now? Why now? Because it is in the Constitution and we must respect the Constitution. It is in the Constitution and we must respect the Constitution. Indeed, it existed, and when the NPP came into office, the NPP removed it. It existed. So it has to come back because it's in the Constitution. And there's no basis for removing it when you haven't amended the Constitution. And I want to indicate, and I argue the same way when we're doing the second reading, that the perception that the tribunal system does not administer justice is just not right. It's just not right. Because excuse me, because we have operated the traditional system of justice with the High Court judges, with the Circuit Court judges administering justice. And let me repeat what I said a few days ago. Today, Afrobarometer's report says that 50% of Ghanaians have no confidence in the judicial system as it is now. As it is now. The answer does not lie in building more courts. The answer does not lie in building more courts. The answer does not lie in appointing more High Court judges. The answer does not lie in being more fast track. There is a fundamental problem of confidence in the system. Okay? And yet, the fact also is that when the tribunal system was introduced, the element of speed in the administration of justice was so effective in galvanizing public confidence in the tribunals. So let me indicate that the fundamental thing about these tribunals is the fact that we are defining the cases that they can handle, and then even more so, we are abridging the processes so that there can be expeditious trial of criminal matters. That is what it is. Now, as for the issue of trust, the issue of why now, and I hear your arguments and you create the impression that the tribunals are being established for the purposes of prosecuting political opponents. But that's not the case. Look at the jurisdiction of the court, the tribunals. Go and look at the jurisdiction of the tribunals. You will see that the range of issues for which politicians tend to be culpable are largely not within the remit of these tribunals. The range of issues, if you look at the jurisdiction of the courts, has nothing to do with a lot of the issues that the tribunals will, politicians get involved in or are alleged to get involved in. So, Mr. Speaker,
Honorable Minority Leader, with all due respect.
Mr. Speaker, if you think that the NDC is proposing the re-establishment of tribunals so that NPP members will be prosecuted, know very well that there will be a day when NDC will also not be in office and MPP will be in charge. So when you come into office, use the same tribunal to also prosecute NDC members. No, yes. Whatever it is, if you are prosecuted and you have not committed a crime, it will be very difficult for you to be convicted. If you haven't committed a crime, you can be subjected to harassment, you can be hauled before any committee, you will be, your time will be wasted, and etc. But at the end of the day, it will be very difficult for a court or a tribunal to just push you into jail when nothing is established against you. Our system is civilized, at least to that extent. As for time wasting, yes. As for harassment, you may be harassed, but you could be harassed without even being sent to a tribunal. You could be harassed just using the investigative bodies alone, without being sent to a tribunal. So it is not a tribunal that will be used to harass political appointees. It will not be a tribunal. I think that the tribunal will do us good if we do what we are doing, which is give them the power to determine matters expeditiously, because that is the major issue that Ghanaians have against the current system of administration of justice. So let me assure you, we are willing to listen to all the arguments and respond to them one after the other, but the fundamental thing is that until we amend this constitution, we cannot look this constitution in the face and say that as a parliament, we are not going to legislate the establishment of a tribunal system, because the constitution recognizes the existence of tribunal system for the administration of justice. That is fundamental. And if you accept that the constitution establishes a parliament and creates the office of member of parliament, you must equally respect the provision of the constitution that says that there should also be a tribunal and that it should be led by chairpersons and then other members. Otherwise, you are contradicting yourself. You are really contradicting yourself. You can't accept the chapter that establishes parliament and members of parliament and reject the chapter that establishes tribunals and the members of the tribunal. I think that this argument really betrays some, fundamental flaw in the way that we are approaching the enforcement of our constitution. So, Mr. Speaker, I urge colleagues that this is the position. It is constitutional. What we should do is how to refine it and make sure that it works until we amend our constitution. And I'm sure that you will have a difficulty even convincing Ghanaians that the provisions on tribunal should be amended out of the constitution, because you haven't convinced them that the regular courts are satisfying them in terms of administering justice. So they would like to try the alternative. Thank you very much, Mr. Speaker.
Honorable Tampoli.
Thank you very much, Mr. Speaker. Mr. Speaker, the matter before us is similar to a situation where you find somebody driving a car. He runs out of petrol and he decides that petrol is a liquid. So maybe let me just put Fritol in the engine and then the car will move. Mr. Speaker, what petrol can do, Fritol cannot do. Mr. Speaker, this tribunal system, during the consultative assembly, in fact, it's been captured in Professor Kwame Ninson's book on the evolution of the tribunal system. And the arguments and the debates have been captured in the book. Mr. Speaker, this is one of the issues that was voted upon, even at the time. Mr. Speaker, with time, the tribunal system was never abolished. It died a natural death. And if you read Professor Kumado's article on the transitional provisions, he labeled it, "Forgive us our trespasses." All the things that have been done during the course of the PNDC era, AFRC era, and all the military regimes were supposed to be part of our history and not to be continued. Mr. Speaker, we have had CDRs, Committee for the Defense of the Revolution. Mr. Speaker, we have had WDC, Workers' Defense Committee. We have PWD, People's Defense Committees. And Mr. Speaker, many of my colleagues here who were younger and older at the time knew about the excesses of some of these situations. Mr. Speaker, the tribunal system was used to abuse Ghanaians, some of whom lost their parents and are now within the NDC itself, because they believe that the NDC has reformed and the NDC is attractive and the NDC has jettisoned some of these situations. Mr. Speaker, when you go back to the tribunal system, you are reminding Ghanaians who have suffered under the tribunal system that we have not finished our democratic, we have not come to a situation where we have forgotten of the past. So, Mr. Speaker, we have not abolished the tribunal system. Mr. Speaker, the situation that we find ourselves in, that we should appoint people to go and sit on tribunals, and then the leader made a point that we can appoint anybody, including PhD holders and so on and so forth. Mr. Speaker, I beg to differ. I beg to differ. What we have right now, our democracy has matured. And it's very important that we do things that will advance democracy. What the Kufuor administration did, and what Atamo's administration did, and what Akufo-Addo administration did, was to correct the backlog of cases by creating more courts, strengthen the existing structure, recruit more judges, have more state attorneys, and so on and so forth. Mr. Speaker, that is the way to go. You cannot go back to this remnants of the revolutionary period. Mr. Speaker, then where do we find ourselves? It's absolutely necessary that we jettison this. Mr. Speaker, it's also very important to state that one of the recommendations of the Professor HKP from Prempeh Constitutional Review Committee was that the tribunal system should be abolished and then deleted from the Constitution. Here we are spending precious time debating on something that has been, more or less recommended to be removed. So we are second guessing what the Constitutional Review exercise is going to be about. Mr. Speaker, let's wait and let Ghanaians decide whether it should continue or not. Otherwise, you are making the work of the president null and void. It's become a nullity. We spend resources to put up the committee to do the work. Allow them to complete their work. Let Ghanaians agree or not agree. If they agree, then we continue. Mr. Speaker, if you go to Section 5 of the transitional provisions, it talks about the discontinuance of the tribunal board, and that the duties and functions and responsibilities of the tribunal board to be handed to the Judicial Council. What is it telling us? The Judicial Council has the capacity to do that kind of work that we want them to do. If there is a need for us to expand infrastructure, the Judicial Council should be able to do so. Mr. Speaker, this is a proposal that is coming from the Attorney General. There's no evidence that the judiciary or the Chief Justice has said that we don't have the capacity. So these are politically created courts to persecute opponents of the regime. But Mr. Speaker, with time, you will finish prosecuting your opponents. And like hyenas, when they cease to get meat, they will eat each other. They will finish eating us and they will come after you because they can't be sitting down idle. So Mr. Speaker, Auditor General report has already cited you. Auditor General's report. Look at the Auditor General report. Mr. Speaker, they will eat you like hyenas. The tribunals will eat you. So Mr. Speaker, let's be very, very careful. When we pass the OSP Act, under His Excellency Nana Addo Dankwa Akufo-Addo, one of the persons who came under attack was my very learned brother and senior, the majority leader. By the time that they left office, the OSP was now consuming NPP people. That should tell you something. It's not going to be one-sided. Let's hasten slowly. We are in a democratic dispensation. Let's expand infrastructure. Let's make sure that the structures will work. Yes, Afrobarometer says that 50% of Ghanaians don't have confidence in the judicial system. Mr. Speaker, similarly, they have said the same thing about parliament. So should we abolish parliament or should we create a second chamber? That's not the argument that we should be having here, Mr. Speaker. Let's strengthen the existing administrative structures for the justice system and not try to replicate and duplicate the functions. And look, Mr. Speaker, some of the things that we are seeing here in terms of how soon they should dispense with cases, 30 days, 60 days and all of that. Mr. Speaker, you are a senior practicing lawyer. Do cases end that way? So we are being told that whether you like it or not, regardless of any interlocutory matters or not, we are working with speed and not the justice that we are supposed to be getting for the people of Ghana. Mr. Speaker, I want to conclude by saying that in tree, and let me say it in tree, Aba Edibo Banu, Aba Edibo Techi, Aba Edibo Techi, and one Edibo Ba. Mr. Speaker, you can go ahead, you have the numbers, you have your way. Mr. Speaker, we will have our say, and we are reminding you for the hazard, for the record to bear, that one day, this dog that you are unleashing on Ghanaians will come and bite you. I thank you, Mr. Speaker.
Yes, you have the floor, but kindly be brief.
Thank you, Mr. Speaker. Mr. Speaker, I support the submission for the deletion of the proposed section 4. Clause 4. Mr. Speaker, the tribunal which is being proposed to be established by this bill is not the same tribunal as provided for by Article 126 of the 1992 Constitution. Mr. Speaker, Article 126 of the 1992 Constitution does not provide for a tribunal which is an independent body, but it provides for a tribunal which is part of the judicial service. And thus, that is why, Mr. Speaker, under Clause 5 of the transitional provisions, the former Public Tribunal Board, Mr. Speaker, was abolished within 6 months of the promulgation of the 1992 Constitution. Mr. Speaker, and the functions thereof vested in the Judicial Council. Mr. Speaker, here we are. A tribunal system is being proposed to be established as an independent body. Mr. Speaker, independent of who? Independent of what? Independent of the judicial service? Mr. Speaker, that is exactly what is being proposed. Otherwise, it would not be independent. Mr. Speaker, that is clearly an unconstitutionality. That is why, Mr. Speaker, we are saying that it is unconstitutional. Mr. Speaker, Clause 4 clearly is an unconstitutionality to the extent that it proposes to be an independent body of the judicial service. And therefore, Mr. Speaker, this House cannot, Mr. Speaker, support it in that regard. Mr. Speaker, again, a regional tribunal, for instance, Mr. Speaker, is already established as part of the Superior Court of Judicature. Now, this bill is proposing to integrate a regional tribunal which is already established as part of the Superior Court of Judicature of this country to be part of a tribunal system which is being proposed to be established. Mr. Speaker, this is clearly an implied amendment of the 1992 Constitution by this bill. And Mr. Speaker, this is procedurally unconstitutional to the extent that, Mr. Speaker, it is inconsistent with the provisions of the Constitution for the amendment of the Constitution. Mr. Speaker, the regional tribunal is part of the Superior Court of Judicature. It cannot, Mr. Speaker, by this bill, be removed and made part of a public tribunal system. That is clearly a proposal to amend that provision, the portion of the Constitution. So, Mr. Speaker, Clause 4 clearly is an unconstitutionality and it should be deleted, Mr. Speaker. This is my humble submission.
Honourable members, please, I intend not to take more debates on the issue, but to put a question to the proposed amendment. Honourable members, the proposal by the minority leader is that Clause 4 of the bill be deleted. I'll put a question. As many as are in favor say aye. Aye. As many as are against say no. No. Honourable members, the noes have it. The Clause 4 is ordered to stand part of the bill. We are on Clause 5. Yes.
Mr. Speaker, I call for a short suspension. I call for a short suspension.
Very well.
I call for a short suspension, Mr. Speaker, so that we can engage.
Honourable Habib,
Mr. Speaker, I want to draw your attention.
you cannot put on your microphone and start speaking. Please.
Mr. Speaker, you said yes.
Please. Please. What is happening? Please, no. You don't have the floor.
Take your time. Take your...
Please. It's not looking good. Normally, if there is an application coming from the majority leader, I throw the application to the minority. That is what I do always. The request is for us to take suspension.
Mr. Speaker.
Please, if you are not going to speak to the request, kindly resume your seat.
Press your mic. Speaker,
Yes, there is a request for consideration.
Mr. Speaker, we want to help you. Help us. Mr. Speaker, we all want to, Mr. Speaker, we all want there to be peace in this house. Mr. Speaker, language, you may not intend, it may not be your intention to spite a member. But Mr. Speaker, sometimes the approach, just as sometimes you see through my actions and correct me, I can't correct you. But Mr. Speaker, my colleague on his feet was first up, then the respected leader made the application for suspension. You want to know our view. And he's telling you that with the greatest respect, we are, the matter on the floor is a vote, which you made a declaration. We are challenging the ruling under Order 1513. The majority leader has also come with an application, which I know it is a strategy, because he suddenly rose and said suspension because he knows we have an application challenging the ruling. So he wants to arrest our application.
So,
Mr. Speaker,
minority leader, with all due respect, when you were a majority leader, I was an opposition member. In a circumstances like this, if you make application of this nature, you are expecting the speaker to ignore the application and hear. So, what has changed?
Speaker, that is not what I'm saying. You are presiding. We are here at the front bench. We know him. Mr. Speaker, we know him. And we are drawing your attention, Mr. Speaker.
Please.
Mr. Speaker, most of the times when he speaks, you don't ask him questions. This is my worry. Please, let us also make the point. I agree with you if you say that upon his application, because he knows his mischief, now he's pretending that he's busy on his phone. You are not pretending to knowing the problem you are causing. But our appeal will be heard. Mr. Speaker, all we are saying is that before responding to his request for suspension, we have a preliminary matter. That is our prayer.
You see, the request is not coming from any ordinary person, but leader of government business. So please.
Mr. Speaker, don't worry. I will solve it. Mr. Speaker, don't worry. It's okay. Mr. Speaker, let the record reflect that if he wants us to take a short suspension, let the record reflect that the vote that was just taken, we, the minority, are challenging the decision of the Speaker in accordance with Order 1513. If he wants us to take a short suspension before this is done, Mr. Speaker, so be it. We don't have a problem. But let it be on record that we are challenging the no vote which arrested our application. Mr. Speaker, that is all we're saying. We're challenging the yes vote. But if he wants us to take a short suspension, so he organizes his members so that they come in for the head count. That is all he's doing. But he's a majority leader. I can understand. No problem. This is one of the tools he should deploy in circumstances like this that he knows he will lose. It's okay. Mr. Speaker, you may decide on his application.
Honourable members, the House is temporarily suspended.